Well, a very good evening to you all. My name is Greg Mackey and I have the privilege of serving as the Chief Executive of the History Trust of South Australia. And on behalf of our Chair of Trustees, Elizabeth Ho OAM, her fellow trustees, senior leadership team at the History Trust and our presenting partner, the University of Adelaide Law School, welcome to the 2022 Dame Roma Mitchell Oration. Before we get proceedings underway, may I acknowledge that we meet on the traditional country of the Kaurna people and pay my respects to First Nation elders past and present. Before I make any further acknowledgements, I ask you to please join me in making welcome Bonnie Brodie to offer a welcome to country.
Namani, Nai Nari Bonnie Brodie, Nai Wakandi, Namani Nabudni, Ganamiana. Hello everyone, my name is Bonnie Brodie and I welcome you all on Kaurna land today. I've been doing these for about 17 years and this is actually my first one since I've started a family. So my grandmother had handed it down to me. So hopefully in the next 10 years you'll see my children doing it for you or your next generation. Thank you.
Many thanks, Bonnie. Now, before I introduce our guest orator, Professor Emerita Ngaire Naffine, as you might imagine, for an event with the prestigious lineage of the Dame Roma Mitchell Oration, while noting that we are all of us special simply for having chosen to attend this evening's event, there are some important people that I wish to acknowledge on behalf of our two entities, the University of Adelaide and the History Trust of South Australia. A welcome to Senator Don Farrell, to Catherine Branson AC, Chancellor of the University of Adelaide, Christopher Kourakis, Chief Justice of the Supreme Court of South Australia, Judge Katrina Bochner, Jodine Carney, South Australia's Commissioner for Equal Opportunity, Michael Coxon, Mayor of the City of West Torrens, Professor John Williams AM, the very able Executive Dean, Faculty of Arts, Business, Law and Economics, do you get it? ABLE, representing Vice-Chancellor Professor Peter Hoy, as well as in his eminent own right as a valued partner. Professor Christopher Symes, Dean of Law at the University of Adelaide Law School, Martin Hazy, former Lord Mayor of Adelaide and CEO of Business SA, History Trust of South Australia Guardians, History Trust colleagues and valued partners, friends, one and all. It is a great privilege for the History Trust of South Australia to be stewarding the Dame Roma Mitchell Oration into the future as an annual event, and we look forward to a continuing partnership with the University of Adelaide. For many years, the Dame Roma Mitchell Oration was co-presented as a major keynote at the Adelaide Festival of Ideas, and given my dual role with the AFOI, for that I would like to acknowledge another guest here this evening, former Commissioner for Equal Opportunity, Linda Matthews. The History Trust is a very busy and incredibly productive public-facing and public-serving statutory authority. Museums, public programs, grant programs, education programs, research initiatives, somewhat not the faceless bureaucracy that some would have us depicted. But I digress. So here we are, ladies and gentlemen, on the precipice of who knows what, living through a global pandemic, Europe fraying at the edges of authoritarian aggression, and our own nation subject to what some would just consider to be a trade war with our major trading partner. Reasons to be cheerful? I invite our eminent orator, Professor Ngaire Naffine, in a minute to say a few words, but before that, I will shuffle my papers and find the next page. Ngaire Naffine is Emerita Professor of Law at the University of Adelaide and formerly Bonython Professor of Law. She's a legal philosopher and criminal law scholar and has also published in the area of criminology and medical law. Ngaire's been a police officer and a legal policy officer in the Women's Advisors Office of the South Australian Department of the Premier and Cabinet, my old stomping ground. She's had a sustained interest in the concept of the legal person law's sustained interest in the concept of the legal person, law's subject or actor, with a particular focus on the relative statuses of women and men. Ngaire's latest book is Criminal Law and the Man Problem. Her previous book, Law's Meaning of Life, asked, who is law for? Who are the main persons of concern? We couldn't think of anybody better to invite to deliver the 2022 Dame Roma Mitchell Oration. Please welcome Professor Ngaire Naffine.
Hello everyone, thank you very much for coming. I'd like to thank Greg Mackey first. He's just been terrific. He's inventive, courageous, and he cuts through things. And the South Australian History Trust and Professor Chris Symes, my Dean of Law, as well as distinguished guests, and I did want to say undistinguished guests, but that would be a terrible joke. And you are all distinguished. And colleagues and friends for coming along in this pandemic. It's really terrific to have you out here. On the day of Dame Roma's death, on the 5th of March 2000, then Prime Minister John Howard honoured the great lady. He said, "All Australians will be saddened by the death of Dame Roma Mitchell." Admitted to the bar in 1934, she became Australia's first woman QC in 1962, made a judge of the Supreme Court of South Australia in 1965, and she was the first in Australia, the first woman, a post she served until 1983, and she was Governor of South Australia from 1991 to 1996, becoming the first woman governor in Australia when she took up the post. It's an exhausting record. She served as Chancellor of this university, and there is a painting by Robert Hannaford over there of her in more mature years. Terrific painter. She was Chancellor from 1983 to 1990, member of the Council for the Order of Australia, served as chairman of the Commonwealth Human Rights Commission from 1981 to 1986, and was awarded a DBE. She became a Dame in 1982 and an AC in 1991. So, Dame Roma was one of the first women in Australia to exercise high-level legal authority in her own right and to exert influence on legal institutions. She became an agent of legal change. She pressed for the rights and duties of women to sit on juries, and she succeeded. Her Criminal Law Reform Committee in the 1970s played a critical role in turning wife rape into the crime of rape. Before that, husbands were not charged for the crime because they weren't committing one, unless they were accessories. This made South Australia a world leader in the reform of criminal law. And in fact, South Australia did many other firsts in terms of law reform in the 70s and 80s. It was just brilliant. But until Dame Roma, every QC, every Superior Court judge had been male. Every governor, every university chancellor. Bears thinking about. All this firstness tells us something simple, but oddly overlooked when we celebrate these pioneering achievements. Before Dame Roma, all these figures of public authority were male, and moreover, they had to be male to have that role. The law required it. Maleness was the basic prerequisite. So Dame Roma challenged the orthodoxy of total male rule, and she kept doing it. You could say that her life was dedicated to questioning orthodoxies. It's hard to view the history of women's exclusion from the polity, from public life, with fresh eyes. The story has been told repeatedly, But I want to say it again, and I want to steer the emphasis a little. The reason why Dame Roma does not have a line of female predecessors is not because women did not want to enter the public sphere. They did. Nor that they were somehow naturally inept or incompetent or hysterical. Perhaps they had a time of the month. But because male public authorities who controlled law allowed only men to participate in the franchise, to acquire a legal education, which would enable them to write treatises and to practice law, to sit on the bench and to sit in Parliament. That's a pretty sweeping removal. As the great American abolitionist Frederick Douglass said in 1848, in this denial of the right to participate in government, not merely the degradation of woman and the perpetration of a great injustice occurs, but the maiming and repudiation of one half of the moral and intellectual power of the government of the world. They're the goods lost. The blockade against women was powerful and it was highly effective. Men in control of the institutions of law and democracy held power tightly to their chests. And legal power was actually returned to men after Dame Roma came off the bench of the South Australian Supreme Court. For the next decade, it was all male again, is my understanding. So it was not a steady unfolding of law reform or women getting in, it was push and pull. The workings of democracy are dynamic and power is rarely ceded easily. As I have found with my membership of the Barbershop Association, which recently admitted women. Sorry, Jim. Nor are wrongs quickly acknowledged. I plan to make 3 points because a speech-writing friend of mine said 3 points are memorable. So I squeezed my first 2 points together. Right, point 1. Legal thought and legal writing has a checkered history, in part because law has been a single-sex institution. But, it's the second half, notwithstanding this past, modern legal scholarship has become sophisticated. It's asking big questions and solving big problems. This has been a terrific exercise preparing this talk because I got to talk to so many of my colleagues and I was honestly stunned at what they were doing. And I wanted to talk about what they're doing and I'm going to. Point two, institutional support and encouragement for such open, adventurous research, indeed academic freedom and autonomy, are being eroded. The culture and purpose of universities, and especially their management, are shifting away from the robust and open pursuit of knowledge. Increasingly, universities look like large corporations, and they are becoming bureaucratized. Point 3, that support for academic freedom and civil, humane working circumstances are needed for the creation of knowledge. And this in turn is critical to democracy. So we should be very worried about failures to support humane research into law, and in fact to support research into all the disciplines. Any failure to support it has a bearing on all of us, we the people. Point 1, legal thought and legal writing have a blemished history, but things have got a lot better. Legal scholarship is now big and deep and wide in its aims and intentions and achievements, but to start with the blemished history. When I was studying law in the 1970s, I was brought up short by some of the open misogyny in the textbooks. I was appalled by what was said about women. And of course, I was a woman, but the textbook did not seem to be written for me. My criminal law textbook spoke of the unreliability of women as witnesses, as complainants, especially when they complained of rape. The book was written from a certain male perspective. Women were treated with open distrust, and I don't think it occurred to the authors that female law students would be reading their text and finding it very disconcerting. But for its understanding of women and their apparent tendency to fabricate, the textbook reached back to the pre-modern period, to the legal writings of Lord Hale. There is now a wonderful Lady Hale who rescued things a lot, on the former Chief Justice of the UK Supreme Court. Hale was treated, the old Hale, as a great legal authority on women's suspect natures, though he was an authority from the 17th century. This was dubious history, antiquated principles, shoddy research, all uttered as straightforward legal truths by some of the most distinguished criminal law scholars in Australia. Much later, I discovered that Lord Hale believed in witchcraft and sentenced witches to death. This extraordinary fact appears to have had little effect on his reputation as one of the great legal treatise writers. Later, when I was writing about the legal status of women and men, and I've spent a lot of time studying the legal person as rights holder, I became interested in William Blackstone and his commentaries on the laws of England. And we have a great Blackstone scholar in our midst, in Wilfred Prest. Apologies, Wilfred. So Blackstone did the great compilation of the laws of England. And he also articulated the principle of coverture. And this is the principle that the existence of the husband, once married, covered the existence of the wife. And she legally disappeared pretty thoroughly. So she effectively became part of the husband. In fact, Glanville Williams, who was one of criminal law's great scholars in England for much of the 20th century, in an early paper said, ho ho, her status was a little bit better than a dog. Now, in explaining this idea, Blackstone conjured up a world of gallant and courteous men protecting the delicacy of women from the harshness of public and commercial life. Now, this was terrible spin, and it was backed up by no evidence at all. So he showed us a view of the world and of law from a male legal elite. He was enormously influential, a huge effect in America, for example, and of course also here. And there he was giving voice to, and he wasn't the first to state it, but he gave it a huge amount of authority, this disappearing of the woman upon marriage. He said it was for the good of women. They would benefit from it. It would protect them. But it amounted to complete legal incapacity, pretty well the inability to do much at all in law. And it made law a single-sex institution. One of his editors, who was Edward Christian, and he was the brother of Fletcher Christian of Mutiny on the Bounty, he did an extended footnote on Blackstone saying this about women and coverture, really saying that it was total rubbish. He did it better than that, but it was 2 pages of saying this is wrong and I cannot put up with this hypocrisy. Even Dame Roma was affected by this thinking, this prevailing male point of view, because we are all people of our time. Yes, she helped to make wife rape a crime, arguably for the first time in the common law world, but her committee's report on the law recommended that it should be a crime only after the husband and wife had separated, otherwise it would put too powerful a weapon into the hands of a vindictive wife. And as recently as 1991, Glanville Williams in England said almost the same thing that it would empower wives too much. In fact, it didn't. I mean, when the law changed, hardly anything really changed. However, pioneers such as Dame Roma did precipitate great change in law and in the study of law. I think she had a huge cultural influence. And I walked down North Terrace and I doffed my hat to her. Seated, I notice. I think Matthew Flinders is very erect, but Dame Roma is demurely sitting there with her books, which is good. So I want to say that research in law is now flourishing, and a lot of this paper now, which is my extended first point, will be about the sort of research going on at Adelaide, in the law school, Adelaide Law School. I acknowledge the excellent work of other law schools. I don't approve of big banners saying, we are the best in the world, we are the most excellent. Our students are all above average, and so on. We have many good places in Australia and in Adelaide. In fact, I don't regard Adelaide Law School as a centre of great privilege. I came to Adelaide Law School from Brighton High School. Our Chief Justice was schooled in Port Lincoln. Our University Chancellor, and they're both here, she was brought up in the mid-north of South Australia, and I have just confirmed that she could drive all the tractors on her family's farm, all of them. Our Dean went to Gawler High School. All of us were educated at Adelaide Law School. In the past several decades, legal scholarship has broadened enormously, and it is now asking the biggest questions. Work's done on a great scale, it's national, it's international, reaches out into space. It's robust, rigorous, evidence-based, expert research using appropriate legal methods. I really wanted to talk a lot about legal method, and I talked to a number of colleagues about very sophisticated legal methods, and I just don't have the time to talk to you about it. So I'm really just going to pose the sorts of questions that they've been posing and encourage you to read their work. So, I understand law as a humane discipline. It's one of the humanities. It considers underlying assumptions and principles, and it considers justice. I mean, I think it's magnificent. I was a very bored 17-year-old at law school, and I didn't have a clue why it was important. And it took me a long time to grasp the immensity of it. For this brief walk through some of the research being conducted at Adelaide, and I should emphasise that this is only a sampling. There are other people here, and for this reason I'm not going to name names or put up photographs, because I want to concentrate on the scholarship and the sort of questions being asked. So for this sampling, let me start with medical law, which is a relatively new subject area, and new parts of law do develop concentrations. They become a new field, as they would with other disciplines. So medical law is now a pretty big deal. So this scholar has been asking, what is it to be unduly influenced when making a decision to end one's life? The concepts of undue influence and duress run through law, because law is concerned with free and responsible decision-making, really right through, particularly in criminal law, which is my thing. These concepts have a long history, and they are complex. They have different nuances and different practical realisations, and they may not translate easily into legislation. So this scholar has been asking, what sort of law ensures that a decision is freely made, and how is that law best translated into real decisions? Fields of law open up and develop, and because I've been around for a long time, I've really seen a lot of movement in the breadth of legal research, in its classifications, how it's moved into other disciplines, borrowed from them and come back, such as philosophy, economics. For example, there is now animal law, and of course environmental law, to which I'll return. Another medical law researcher is asking how biotechnology is changing the law of the body. And this could be regarded as a new branch of law, and I think she's helping to develop it, body law. Now people record their own bodily activities on their smart watches. A number of you might do this. As this scholar said, I quote her, "Bodies and bodily substances are no longer valued and viewed primarily for their physical properties, like arms and legs and heads. Increasingly, they are information, and that information has become valuable, very valuable. We hand over information about ourselves for genetic testing, if we're brave enough to. We may leave bits of ourselves in hospital, and they might be used, and there's been controversies about that. And those bits of our bodies may contain very important information. When bodies were material things, and for some reason I spent some time studying the legal status of corpses. And in fact, once I was invited into the Anatomy Museum at Edinburgh Medical School because they thought I was a doctor, and I wasn't. It was horrible. It used to be that we didn't own ourselves. That was the law of the body. No property in a body. We don't own ourselves. And when and if we're buried, no ownership of a corpse. And it was really quite interesting, the no property in a corpse rule. This quasi-property law is no longer suited to the job of regulating our bodies as information. So how are we now best protected? Who should control this bodily information? Who should be able to use it? What sort of laws best do this job? And my colleague is looking at whether it should be property law, privacy law, some new mix of laws. So it's really quite path-breaking scholarship. Labour law. The law of work, or labour law, has also been a strong research interest at Adelaide, including the study of the precarious working lives of migrants and the nature of their work. So another colleague is asking really quite a philosophical question, which is, what is it to be employed? What is it to work? She observes that work is much more than just a wage in exchange for work. It shapes people's lives, their identity, their livelihood. We can become our work. So how does law define employment? Can it and does it reflect this richness of being? And how does it deal with the great power imbalance between employers and employees and protect the employee from exploitation? There's also strong policy work going on in labour law. So one of my senior colleagues was very influential in the drafting of the Fair Work Act of 2009. And that same person has been part of interdisciplinary teams looking at unpaid work, its nature and prevalence, and also the gig economy, so really up to date. Criminal law, which is my love. Legal scholars are often polymaths. They move across different parts of law, and they are interdisciplinary. And it's a great joy, actually. I was once having a chat with a couple of distinguished law professors, and they said to me, it's just terrific doing law because you can go off and do a bit of philosophy and you don't really have to master it, and you can come back and apply it to law. And I think law is our stable core discipline. So we might use philosophy or sociology or criminology or economics or physics even. Another colleague has conducted two quite different inquiries. For one project, she's been asking the question, is there a connection between military service and criminal offending? She was aware of the growing international concern with the over-representation of the military in prisons with veterans after the military. And hers is, as she says, the first study in Australia to consider the connection between military service and criminal offending. And to answer her question, she's going into prison and she's talking to them about their lives, whether they were perhaps abused in childhood, which she has found, the effects of military service, what happened afterwards. In another research project, this same scholar is looking at the Office of the Director of Public Prosecutions. Has done so very thoroughly. As a defence lawyer in a former life, she wondered what went on in the DPP's office. It was mysterious in some ways. They would produce decisions not to proceed with a matter, which could be welcome, but it was not entirely clear why. Not that they were welcome, but what was going on. It was then she started looking very closely at the office, the rules and principles governing the Office of the Director of Public Prosecutions. She discovered that that office was required to be both independent of political influence and accountable, but that accountability took the form of oversight by the Attorney-General, who is answerable to Parliament, but this is by definition a political office. The paradox, as she says, is that the political role that compromises independence also protects accountability. She also found out that the office worked nevertheless pretty well, despite these internal tensions, and the significant discretion it gave prosecutors. And to my mind, that is part of our broader civil culture, that we can often really count on officials such as these. Another criminal law colleague is an international expert on the codification of law and has had a considerable influence on the formulation of Australia's Criminal Code Act, which, among other things, set out the general principles of criminal responsibility. Yet another Adelaide scholar is researching the law of climate change and the technologies which are trying to stop catastrophic events. She explains that these technologies respond to climate change by drawing carbon dioxide directly from the atmosphere or by reflecting a percentage of sunlight away from the Earth by making clouds whiter. And this is being tested on the Great Barrier Reef. Cloud brightening technology to shade the reef. And her work has been cited by the UN Convention on Biological Diversity and the Intergovernmental Panel on Climate Change. Very different work on the environment is being done by our beloved Dean of Law, Professor Christopher Symes, who is a world expert on insolvency law. Now, I didn't know that insolvency law was this exciting, but it is. It is the law of debtors, people who cannot pay their debts. He studies not just debtors and creditors, but the community. And he takes a very broad view of what makes up the community, and he includes the environment within that community. His most recent work is on the intersection of environmental law and insolvency law. And he said that he wants to give voice to the voiceless. He says this matters, and I often said to my colleagues, well, why does this matter? Which they always know why it matters too. None of the research is done for the sake of it. It's always because it matters significantly. Chris says this matters because employees deserve their wages, despite their employer's insolvency. The environment deserves a clean-up from contamination, even if the owner is insolvent. And creditors deserve to be paid, even the money has been moved offshore and the company wound up. Our former Dean, Professor Melissa de Zwart, now at Flinders, she did a runner, which is very sad, is an international expert in law and technology, internet law, and the regulation of access to and uses of outer space. And space law and military law are now major research concerns at Adelaide. Also at Flinders, Adelaide alumna Professor Margaret Davies is developing a new type of natural law. She's arguing that animals, plants, and earth systems produce their own values and norms from which human norms and laws emerge. Now, you may want to take up those propositions with her. So legal research now reaches out into space and into the earth. Finally, Greg, when do you want me to stop? Give me time. What? Have I got plenty of time? Plenty of time, good. I've got a lot to say. It's always that on the spot cutting which is desperate making. International law has been a big long-standing research concern at Adelaide Law School. In 2017, Australia ratified a human rights treaty known as OPCAT, the Optional Protocol to the Convention Against Torture. One scholar in the law school is working on a system of independent detention monitoring to prevent the risk of torture and ill treatment in all places of detention. Now, this includes youth detention centres, disability settings, and residential aged care. Another colleague, as she's put it, has devoted her whole scholarly life to improve the protection of civilians and civilian objects, buildings for example, from the effects of armed conflict through international law. So she was giving me an illustration of this. If a commander needs to make a decision about the lawfulness of bombing a building with some enemy agents within it, and there are many civilians, when do you know whether it's lawful? I don't know if this is the right question, but how many civilians can you lawfully kill? She's telling me that's right. Former Adelaide Law Professor Hilary Charlesworth is now a judge on the International Court of Justice, the World Court. And only a month ago, it granted provisional measures against the Russian Federation in response to the application of Ukraine under the Genocide Convention. These measures include the order that the Russian Federation must, pending the final decision of the case, suspend the military operations that it commenced on the 24th of February in the territory of Ukraine. So that's been the pending decision of the court. So the university lawyer moves across empirical work, the study of observable facts, across policy. They formulate and test new ideas, and they pass on their knowledge to the next generation. And they are all committed to advancing justice and equality. I had 4 wonderful years teaching the honours students research and writing, and the idealism and talent of these people was, the sheer goodness of them was marvellous and so clever. The modern legal scholar conducts robust research designed to test big ideas, correct falsehoods, combat prejudice. Doubt and the willingness to be wrong are fundamental to this process and also humbling. This is the great civilising and enlightening role of the international lawyer, the legal scholar, vis-à-vis the law and the polity. So to complete this very long first point, I want to say that legal research is characterised by a willingness to be wrong, to be uncertain, to entertain doubt, and also to deal with complexity and to face horrors. I think a lot of my colleagues really look at the most terrible things boldly, and it takes a good deal of courage. And they question orthodoxy, and they're willing to be contrarians. Point 2, that support for such open, adventurous research, indeed academic freedom, is being eroded and is now under threat. For this research to flourish, it must have the right conditions. It is hard work, time-consuming. It demands extraordinary commitment, sacrifice. They work all the time. It needs to be conducted without haste, independently, autonomously, robustly, according to the expertise and legal methods of the scholar. We are currently observing the growth of anti-democratic values across the world, the rise of totalitarian regimes, and it is noteworthy that academics who stand for free thought are often targeted. Independent, expert, fearless research, which provides reliable expert knowledge about our world, is an important reply to totalitarianism and propaganda, and so it serves a broad, universal political and social purpose. But in my view, and in the view of many others, it's under threat, this robust research, even in the liberal democracies, and we should be worried about it, as the main learned academies are worried. There has been a worrying rise in bureaucracy across the university sector and a steady growth of administrators without strong accountability or transparency of their decisions. The rise in the number of administrators is a long-term trend. They now well outnumber the scholars and teachers, even though the job of a university is to educate and research, which only scholars and teachers can do. Without the scholars and teachers, there is no university. Perversely, the growth of administrators in the university has increased rather than decreased the workload of academics. There are more and more forms to be completed by academics in what can appear to be a bid to finally control them, to require them to report often. But this means that they've got less and less time to do their research, so they may have less to report, and it's a bit mind-numbing. This is causing distress across the sector. Scholars are being squeezed by sometimes back-breaking workloads, large staff-teacher ratios, especially in law, which takes a lot of the students, and large marking loads, giving them less and less time to be scholars, even though they are measured by their publications, and most scholars define themselves as researchers. And curiously, the perceived social value of the academic as expert has fallen, which I think you've probably all observed. Expertise has been devalued, and job security has diminished. Academic autonomy and the curiosity and questioning that should go with it are being stifled by very difficult working circumstances. Excuse me. This was something foreshadowed by the social critic George Orwell in his dystopian novel 1984. We are witnessing the emergence of a strange culture in which there is top-down instruction to academics from non-academics about what academics should be doing. Accountants may scan the workload of academics, looking for savings and greater productivity. Students have been stakeholders, they've become stakeholders, clients, and I think I have heard them referred to as customers as well. That might have been a nightmare I had, but I have a feeling I've heard the word. And you know customers can't be wrong, which at marking time creates difficulties. At the same time, there has been a move away from clear, open, intelligible communications and writing from management. Writing which engages and explains, which genuinely invites consultation and criticism and discussion. George Orwell had grave concerns about the degradation of language and thought, and he expressed these concerns in a famous essay which always bears rereading, Politics and the English Language. It's probably one of the best essays, I think, on honest, clear writing and the politics of it. What can happen if it's not true? Orwell pointed out that if language is degraded, so too is thought. His novel, 1984, anticipated what can happen if language were no longer used to communicate, but was taken over for the purposes of the control of a population. Universities now look a lot like big corporations rather than teaching and research institutions. There are now CEOs, executive directors, many managers, many sub-managers. Often the perceived task is to manage a business. And it's an enormous business, as Greg Mackey pointed out. It's a huge bureaucracy, it's a big business. But in managing this business, there tends not to be an encouragement of fearless debate and controversy, which I think is what a university is all about. Often the workings of the university are a mystery to those doing the research, those asking the big questions and doing the teaching, because decision-making is no longer at the level of the school or department. And yet the University of Adelaide Act says the object of the university is the advancement of learning and knowledge, including the provision of university education. This is a clear, uncorrupted statement of what the university is for: advancement of learning and knowledge, including the provision of university education. It reminds me of Sir Humphrey when he said this hospital was working perfectly well because it didn't have anyone in any of its beds. There was a problem in the understanding of a hospital. That is to say, universities are better regarded as teaching and knowledge institutions, places where new knowledges are made with rigorous testing by those with appropriate expertise, and this requires support and encouragement and open, robust and difficult debate. Controversy should thrive in a university and not be discouraged or closely monitored. People need to feel appreciated, consulted, listened to, valued, informed. But this is not how the modern university feels to the researchers and teachers, who are the essence of the university, as our Governing Act makes clear. The recent interventions of the federal government into the processes and final decisions of the Australian Research Council and its selection of grants after a very long, careful, painstaking process should cause concern. It has actually, enormously. So too should the implicit steering of students away from the arts and humanities, including law, by the raising of fees. As Professor Gavin Moody said yesterday in the conversation, the more than doubling of humanities fees by the federal government policy of job-ready graduates signals a devaluing of fields which are intrinsically valuable in understanding society and culture's handling of health measures, which are particularly important, as we have seen in the past 3 years. We need arts, we need humanities, we need science, we need law. My third and final point is that academic freedom and civil humane circumstances for the conduct of research are critical to the support and promotion of a humane civil society, to democratic values and a democratic accountable state. I see legal research, legal scholarship, as a branch of philosophy in that it asks fundamental questions. It tests assumptions. It teases out the nature of concepts. And of course, it nearly always links these first-order questions to the forms of law and the nature of justice. This is an inherently civilizing form of inquiry, strengthening one of our most basic institutions. I had a look at the Encyclopaedia Britannica to see what it said about the humanities. So this is from Britannica. The humanities are those branches of knowledge that concern themselves with human beings and their culture, or with analytic and critical methods of inquiry, derived from an appreciation of human values and of the unique ability of the human spirit to express itself. And I think that's just terrific. And it's how I feel about it, and I think it's how my colleagues see it too. So with the threat to free, robust and measured research into the humanities, civil society is under threat. This is being said by scholars nationally and internationally. Melbourne law professor Adrian Stone valiantly gave a lecture in her office because of the pandemic, and it was a public lecture. And there she gave forth on the nature of democracy and scholarship. And I thought it was just so plucky to be in an office and do this and speak to the world. And I know the pandemic's doing that. She says, and she's a very posh scholar of constitutional law and legal philosophy, universities are essential elements of democracy. She says universities play an important role in support for democracy as independent sources of information and knowledge, sort of a third branch, integrity officers. And she likened them to electoral officers, actually, integrity commissions. But, in turn, she says, universities themselves require a commitment to democratic government in a full sense. Universities thrive in societies that are truly committed to free academic inquiry, that are prepared to wear the discomfort that challenging independent thinkers can bring. Harvard law professor Vicki Jackson, in a pretty recent article, also said, universities are knowledge institutions, and the provision of knowledge is part of the infrastructure of democracy. The American Association of University Professors, in a document entitled In Defense of Knowledge in Higher Education, said this. It's a longish quote, but I think it's good. Expert knowledge is a process of constant exploration, revision, and adjudication. Expert knowledge is subject to endless re-examination and re-evaluation. It is this process of self-questioning that justifies society's reliance on expert knowledge. Such knowledge may, in the end, prove accurate or inaccurate, but it is the best we can do at any given time. That is why we are largely justified in relying on it. It's not dogma, it's careful, slow inquiry, which may not get anywhere, but it might. And it's the best we can do. Finally, the expert on democracy and civility, Professor John Keane, he has declared that democracy depends on the expert and their expertise. He says experts can play the role of contrarians, defenders of institutional pluralism, champions of public debate and controversy, and citizens of wisdom. He's very eloquent. They are agents of humility, he doesn't believe in understatement, and characters who can prevent orthodoxies from taking grip. I think that's good. Can prevent orthodoxies from taking grip. All of this tells me that strong, confident, robust, scholarly institution and a fully democratic government should want orthodoxy challenged. It should want a profusion of voices and ideas, for thus is civil society and democracy strengthened. To conclude, you've had my 3 points. Universities need to be open rather than closed. And it's pretty glorious that we're here in Bonython Hall, actually. I didn't realise how beautiful it was. They need to encourage the asking of questions freely, the taking of risks, an abundance of ideas, as a friend said to me, some of which will be discarded and some of which will work. Not just narrowed down to the current winner, a proliferation of ideas. Law within the university sector is a humanitarian discipline. Its research is to do with the uses of soft and hard power and the checking and extension of civility. The History Trust is also part of the promotion of humane values, of culture. And hats off to Greg Mackey and his colleagues. And may I put a plug in for the History Festival too, which looks wonderful. My long and close association with a great humanitarian historian, Professor Eric Richards, taught me much about this. So I'm especially thankful to the History Trust, as well as my Dean, for bringing this oration into being. And I'm also grateful to my friend Jim Lister for urging me to expound boldly on the importance of independent ideas and helping me to stay to the allotted time. Over my long career, I have encountered an open, encouraging environment, and I have found this in other law schools. I am a beneficiary of it. I don't want it lost. Dame Roma was bold and fearless. She believed in universities. She was a chancellor here at Adelaide. She made Adelaide University a handsome bequest because she anticipated its future. For those of you who want to learn more about Dame Roma, I commend the excellent biography of Dame Roma by Susan Ngaire and Kerry Round. I believe Dame Roma would want the values of free thought honoured, an open university, and an academic community which felt secure, which was consulted and had a say. She became an authoritative legal woman and an agent of change. I am confident that she would want legal inquiry to continue and flourish and not be cut down. Thank you.
Thank you so much, Ngaire. Much food for thought. I'd now like to invite to offer a vote of thanks, Professor John Williams, AM.
Chancellor, Professor Naffine, Chief Justice, Judge, Senator, Commissioner, colleagues and friends. I'm greatly honoured to be asked to move this vote of thanks to our orator and the organisers of this important event. I start by acknowledging the Kaurna people, the university, through the efforts of its staff and students, continue to work with the original owners of the land to bring about a shared future. I'd like to thank the History Trust of South Australia and especially Greg Mackey and the Board of Trustees chaired by Elizabeth Ho for maintaining this important public oration in honour of a trailblazing South Australian jurist. I also wish to acknowledge and thank the Dean of the Adelaide Law School, Professor Chris Symes, and the External Engagement Branch of the University facilitating tonight's event. This event would not have been possible without the work of many, so would you please join me in thanking them. To our orator, Professor Naffine, I'd like to thank you for your thought-provoking address tonight. A learned contribution to the questions surrounding the shape and the commitment of a civil society is indeed timely. Amidst two general elections, it is noteworthy what is and what is not being viewed as part of the political narrative as critical to attracting public approval and political success. Professor Naffine has, through her scholarship, established herself as an international figure within the discipline, and we are fortunate to have her deliver the 2022 Dame Roma Mitchell Oration. Can you please join me in thanking again Professor Naffine? And lastly, I'd like to thank you all for your attendance here tonight. The circumstances of the last 2 years have greatly affected many of our friends and families. It has also challenged many basic acts of community, such as joining together to consider, debate, and directly participate in a deliberative moment. Let us hope tonight represents an important step back to what we all value, to be in each other's company. Thank you.
Thank you so much, John. And in concluding, I echo his thanks to you all for joining us this evening. I thank Professor Ngaire Naffine for a very, very thought-provoking address, and I look forward to watching it on stream very, very shortly. And ladies and gentlemen, ideas and the law are inextricably linked. I am very, very privileged, we are very privileged at the History Trust to have been invited to steward into the future the Dame Roma Mitchell Oration, which I'm very pleased to say, I'll take a bit of a leap of faith here, will from here on in be an annual fixture rather than a biennial fixture, and we look forward to your future attendance and engagement, and we thank you and welcome any feedback. Ladies and gentlemen, you've been a fantastic audience. Thank you so much for your attendance in this trying time, and I wish you a good evening and safe travel.